Welcome to all. In today's class, as a part of the course on insolvency and bankruptcy law in India, in today's class, we are going to discuss the concept of pre-packaged insolvency resolution process under IBC. So before that, let us recap what we have discussed in the previous class. In the previous class, we have discussed about fast track resolution process, FTP. Then who is eligible for fast track resolution process, we have discussed. Then application for fast track resolution process, how to make an application, who can make an application for fast track resolution process, we have discussed. Then stages in the fast track resolution process, we have discussed the stages in the fast track resolution process in detail. Then time framework for fast track resolution process, we have discussed. Now in today's class, we are going to discuss what is PP-IRP, then who is eligible, and other things relating to PP-IRP. So what is PP-IRP? PP-IRP is a streamlined and alternative insolvency resolution mechanism. So pre-packaged insolvency resolution process, it is a streamlined and alternative resolution mechanism exclusively designed for MSMEs, medium and small scale industries. So for MSMEs, this scheme was introduced. Then chapter 3A of IBC, which where we are having the provisions from section 54A to section 54P, so which deals with these sections, section 54A to section 54P. These sections deals with the provisions relating to PP-IRP, pre-packaged insolvency resolution process. Then apart from this, so chapter 3A of IBC and Insolvency and Bankruptcy Board of India, pre-packaged insolvency resolution process regulations 2021. So chapter 3 and regulations we are having. Then who is eligible? A corporate debtor is eligible to initiate PP-IRP if it is an MSME. So one of the basic condition to be satisfied to initiate PP-IRP, that is pre-packaged insolvency resolution process under this act, is that it should be MSME. Then the corporate debtor must be classified as micro, small or medium enterprise under the MSME Act, because we are having MSME Act is there, separate MSME Act is there. So under that legislation, it has to be categorized as MSME. And what is the default threshold? So if you want to go for PP-IRP, default threshold limitation is the minimum default amount should be at least 10 lakh rupees. So if the default amount is at least 10 lakh rupees, then you can go for PP-IRP. Let us discuss further conditions. And there should not be any PP-IRP, CRP formerly. So if any company, if any CD, corporate debtor, has already undergone the PP-IRP or CRP previously, then in such cases, again you cannot go for PP-IRP for the second time. Then the corporate debtor is not undergoing a corporate debtor CRP process previously, then no PP-IRP has been initiated or completed for the corporate debtor in the preceding 3 years. So the limitation is 3 years. So in the preceding 3 years, there should not be any PP-IRP formally. Then no liquidation order. So another condition is that there should not be any liquidation order. No order of liquidation should have been passed against the corporate debtor. So if the liquidation order is passed against the corporate debtor, then you cannot go for PP-IRP. Then corporate debtor must have obtained a special resolution. So what is the procedural aspects to be followed? The procedural aspects to be followed are a special resolution to be passed. Okay, you are expected to conduct the general meeting. Then at the general meeting, you are expected to pass the special resolution. Okay, or a resolution passed by at least 3/4 of the total number of partners. So suppose in case if it is an LLP, then in such cases there is no concept of special resolution. So that's why 3/4 majority. So you need to pass the resolution through with 3/4 majority. Then approving the initiation of PP-IRP. So what should be the agenda of the resolution or agenda of the meeting? The agenda of the meeting must be to approve the PP-IRP. So you should have passed the special resolution in case of a company. In case of LLP, okay, 3/4 majority. The application must be approved with the 3/4 majority. Then the CD shall obtain an approval from its FC. So corporate debtor shall obtain an approval from the financial creditor, not being its related parties, representing not less than 66% of the value of the financial debts due to such creditor. So the regulation 14 further provides that if you want to go for PP-IRP, another condition is that you are expected to get the approval from the financial creditors. Okay, so when you are getting approved from the financial creditors, it should be with the majority of 60% of the vote, 60% of the value. But please remember, while calculating this 66% or percentage, we are not supposed to include related parties. So already in the previous classes, we have discussed who is considered to be related party in detail. So the related parties are not included while calculating or while considering the 66%. Then, okay, before seeking approval, the CD need to provide such documents as may be prescribed under section 54 subsection 4. So under section 54 subsection 4, already we are having the provisions we have already discussed, where whenever if you want to get the approval from the financial creditor, you are expected to give certain documents. Okay, so certain documents and certain disclosures must be made to the financial creditors. So all these disclosures and documents already we have discussed in the previous lessons. Okay, so before seeking approval, the CD need to provide such documents as may be prescribed under the legislation. Then who can act as a RP? It is simple logic. So whoever is eligible to act as a RP in the regular CRP process, okay, the same person is also eligible to act as a RP even in the case of PP-IRP. So I can tell you that PP-IRP is nothing but replica of regular CRP process only, but timelines are different. Comparatively, timelines are different. Other than that, more or less all the process relating to CRP will be applicable to the PP-IRP also. Now let us look at the regulation 7. Subject to consent in form number P1, an insolvency professional shall be eligible to be appointed as an interim resolution professional or RP as a case may be if he and all partners and directors of the insolvency professional entity of which he is a partner or director are independent of the corporate debtor. So that means if I want to appoint someone as a resolution professional, okay, he should be independent person. Let me tell you in another language. Whoever is eligible to be appointed as an independent director, okay, such person is eligible to be appointed as a resolution professional. So that means he should not have, as already we have discussed in the previous classes also, the resolution professional or any person to whom we wanted to appoint as a resolution professional, such person is not expected to have any material pecuniary relationship with the company. He should not be having any relation with the company. So if he is having any relation, then he is not eligible to be appointed as a RP. Let us discuss some other key points. The RP shall prepare a report in form P8. Okay, so in this lesson or under the regulations, all the forms will be P1, P2, P3, numbering will be P1, P2, P3 like that. Okay, so the RP shall prepare report in P8. The fee payable to insolvency professionals in relation to the duties performed under section 58B, it shall be determined, okay, as may be specified under the legislation. So under the legislation already COC, they are going to, already we have discussed that how much remuneration we can pay, schedules are there, but the COC is going to fix the remuneration to be payable to the insolvency professional. Okay, the same provisions, okay, so whatever provisions that we have discussed previously in the previous lessons, the same provisions are also applicable even in case of resolution plan, okay, resolution professional in case of PP-IRP. Then regulation 14, okay, which provides that approval by the FC, financial creditor. The notice of the meeting under this regulation shall indicate the date, time and venue of the meeting and enclose a list of creditors along with the amount due to them in P4. So please remember, regulation 14 provides that you have to get the approval from the FC, financial creditor. Okay, the notice of the meeting under this regulation shall indicate the date, time, venue of the meeting and the enclose of list of creditors. So please remember, before considering the list of creditors, first you have to send the notice to the creditors. Okay, so stating that these are all the creditors and the list of creditors and how much amount it is due, everything you are supposed to give. Then authorized representative can be appointed. So there is a possibility for representing the class of creditors. So as already we have discussed in the previous lessons, there is a concept called as class of creditors. So if any class of creditors are there, then in such cases they can appoint the authorized representative to represent them in the committee of the creditors. So there is a possibility even in the case of PP-IRP also, authorized representative can be appointed by class of creditors, which is provided in regulation 15. Then let us discuss initiation of PP-IRP. Section 54C, where the corporate debtor meets the requirement under section 54A. So as already we have discussed the requirements, MSME, it should be MSME. The triggering point is 10 lakh rupees. So like that we have discussed the eligibility criteria. Okay. So where the corporate debtor meets the requirement under section 54A, a corporate applicant thereof may file an application with the adjudicating authority for initiating pre-packaged insolvency resolution process. So who can make an application for initiation of PP-IRP? It's a corporate applicant. Okay, it's a corporate debtor, it's a corporate applicant. Okay, so they can make an application for initiation of PP-IRP. Okay, then once the application is made, okay, so these are all regular procedure already we have discussed. Okay, once the application is made with the NCLT, the adjudicating authority within 14 days, either he may admit or he may reject the application. Okay, so whenever if he is admitting, so there is no concept of judicial discretion, much judicial discretion will not be there. Okay, so whenever if he is admitting, he will verify whether did they follow the procedure or not. Okay, so if they don't follow, then in such cases he will give an opportunity to the opposite person to rectify the mistakes, then accordingly again he can submit. Okay, so or else he can reject the application if it does not satisfy the conditions. Okay, then PP-IRP shall be completed within a period of 120 days. So another important provisions that is there under section 54D is that the PP-IRP shall be completed within a period of 120 days. So if you observe the regular CRP process, it shall be completed within a period of 180 days, extension 90 days, 270 plus maybe it can go up to 330 days as already we have discussed. Okay, timelines we have discussed in the previous lessons. One of the lesson is timelines. So in the timelines lesson we have already discussed how they are going to calculate. Okay, but whereas in case of PP-IRP it has to be completed within a period of 120 days. Okay, then please remember, once the application is made, okay, under section 54C, when the adjudicating authority is admitting the application, okay, then in such cases, immediately adjudicating authority is going to declare the moratorium also. Already we have discussed in the previous classes the importance of moratorium. So you cannot file any case against the company during the moratorium period. Okay. So once the initiation is done, once the insolvency, this admission is done, that is adjudicating authority admitted the application, immediately moratorium will be enforced. Okay, that is section 54E. Then let us discuss about duties, powers of the resolution professional. More or less these duties and powers of the resolution professional are similar to the regular CRP procedure only. Okay. So what is the first duty? He is expected to inform the creditors, okay, regarding their claims as confirmed under clause A in such manner as may be specified. So once the resolution professional is appointed, he is expected to give the announcement. After the announcement, he is going to receive the claims. Okay, he is going to prepare and collect and collate the information. So once that is done, okay, so he is going to inform the creditors regarding their claims. Okay, then maintain an updated list of claims in such manner as may be specified. So already we have discussed in the previous classes also. Okay, so it is the responsibility, it is a duty of the resolution professional to maintain and update the list of claims, because there is a possibility the claims may be received in a phased manner. Okay, so as in when you are receiving the claims, you are supposed to update the register from time to time. Okay, then monitor the management of affairs of the data. So this is one of the core feature of the IBC itself. Okay, so even if you observe under CRP also, once the resolution professional is appointed, either IRP or RP, once the resolution professional is appointed, the existing board of directors is suspended. Okay, so the resolution professional is going to replace the existing board of directors. So that's why he is going to monitor the management of the affairs of the corporate. So entire management will be in the hands of the resolution professional only. Then constitute the committee of the creditors and convene and attend all its meetings. So another duty of resolution professional is that once the resolution professional is appointed, he is going to constitute the committee of the creditors. He is going to receive the claims. Accordingly, he is going to constitute the committee of the creditors. Okay. Then he is going to conduct the meeting. As already we have discussed in the first meeting, there is a possibility IRP may be continued as RP, or else they may appoint another person as a resolution professional. Okay, so he is going to constitute the committee of the creditors and convene the meetings and attend all its meeting. Okay, it is the responsibility of resolution professional to attend all the meetings. Okay, then resolution professional is also having power to access the books of accounts. Okay, so as already we have discussed in the previous classes also, when the resolution professional is appointed, it is the responsibility of the suspended board of directors to cooperate with the resolution professional. They are expected to cooperate and they are expected to show the records. So he is having power to access the books of accounts. Okay. Then power of the resolution professional to appoint professionals. So if you observe regulation 10, because the resolution professional is replacing the board of directors, practically speaking, it is not possible for him individually to manage the entire company. So that's why, okay, so he's having power to appoint the other professionals also. He can take the help of other professionals and he can run the business accordingly. Okay. Then attend the meetings of the members and board of directors and committee of directors or partners as the case may be. So once if he is appointed, okay, so actually he is the person who is going to conduct the meetings. So he is supposed to attend the meetings, okay, so of the members as well as board of directors and the committee of the directors, etc., etc. Okay. Then let us discuss about the claims. Section 54G provides for the claims. A corporate debtor shall, within 2 days of the PP-IRP commencement date, so within 2 days from the PP-IRP, that is, once it is admitted by the NCLT, such date is called as commencement. Okay, so on such date, PP-IRP is commenced. Okay, so once the commencement is done, within 2 days, okay, he is expected to submit to the resolution professional. Okay, corporate debtor, I am talking about the corporate debtor. Okay, corporate debtor is expected to submit to the resolution professional following information. Okay, so what is expected to submit? The list of claims along with the details of respective creditors, their security interest and guarantees if any. So because the application is initiated by the corporate debtor, he is expected to give this information to the resolution professional once if he is appointed. Okay, list of claims along with the details of the respective creditors and their security interest. Then a preliminary information memorandum containing the information relevant for the formulation of resolution plan. Then a creditor may submit an objection. Okay, so once that is done, so there is an option is there to the creditor under regulation 20. A creditor may submit the objection along with the supporting documents. So along with the supporting documents, that is invoice, etc., etc., he may submit the claims. Okay. Then where the amount of the claim of creditor is not precise, possibility is there he is unable to decide what is the exact amount, it is not precise due to some contingencies. In such cases, the resolution professional, okay, he is expected to make the estimation. Okay, so based on the transaction, he can make the estimation accordingly. Okay, so he is going to admit the claim according to the estimation made by him. Okay, then if you observe regulation 22, the claims denominated in foreign currency shall be valued in Indian currency, because you are going to settle the issue under Indian law and you are going to settle the amounts in Indian currency. So that's why if any claims are denominated in foreign currency, okay, such currency must be converted into Indian currency and Indian rupees. Okay, so at the official exchange rate as on the pre-packaged insolvency commencement date. So as already we have discussed, once the NCLT admits the application, such date is considered to be date of commencement of PP-IRP. So as on that date, whatever may be the foreign exchange ratio, that ratio or that exchange price must be accepted, must be considered. Okay. So where a creditor assigns or transfers the debt due to such creditor to any other person during the process period, both parties shall provide the resolution professional the terms of such assignment or transfer and identity of the assignee or transferee. Suppose take the example, there is a creditor is there. During the PP-IRP process going on, maybe the creditor may have transferred, or he might have maybe assigned his right in favor of other person. Then in such cases, such assignment or transfer must be submitted before the resolution professional, okay, along with the evidences. Then let us discuss other important provisions. The resolution professional shall, within 7 days of the PP-IRP, that is pre-packaged insolvency commencement date, constitute a committee of the creditor. So within how many days he is expected to constitute? Within 7 days he is expected to constitute the committee of the creditors. Okay. Then the vesting the management of the corporator with the resolution professional. So once the resolution professional is appointed, as already we have discussed, the existing management cease to be in existence. Okay, so there are no more board of directors of the company. So the resolution professional is going to be replaced with the existing board of directors. So he will be vested with the entire management of the corporator. Okay. Next, suppose take the example where the corporator has only creditors in class. Okay, there is no other financial creditors, but creditors in class are there who are not related to the related parties to the corporator. Then the committee shall consist of only authorized representative. Suppose if the company is having class of creditors, then already we have discussed in case of class of creditors you can have the representatives. Okay, so in such cases the committee shall consist of only authorized representatives. Okay, then suppose take the example if CD has no financial debt or else all the financial creditors are related parties. So as already we have discussed, if any financial creditor is a related party, he cannot be a member in the COC. Okay, or else if the CD is not having any financial debt. Okay, then in such cases, the committee can consist of only operational creditors. Generally, operational creditors will not have any say or they will not be part of the committee of the creditors. But here, if the company does not have the financial creditors, then in such cases, okay, the committee can have only operational creditors. Then let us discuss about the procedure governing the meetings of the COC. Okay, so we are having regulation 27 of the PP-IRP regulations which speaks about meetings of committees. How you are supposed to conduct the meetings of the committee, which is provided under regulation 27. Then notice for the meeting to the committee. So how to send the notice? Regulation 28. So you are expected to send the notice to the before meeting. You are expected to send the notice. So please remember, whenever you are sending the notice, along with the notice, you are expected to send the nature of the meeting and time, place and date of the meeting. So when you are conducting, where you are conducting, you are expected to disclose time, place and date of the meeting. Okay, so these things must be there along with the notice. Then service of notice for the meetings of the committee. So whenever you are conducting the meeting, so regulation 29 provides that for each and every meeting, it is the responsibility of the resolution professional to serve the notice for each and every meeting. Okay. Then what should be there in the contents of the meeting? As already we have discussed, if you observe regulation 30, which provides that the notice for the meeting should contain the date of the meeting, place of the meeting, where you are conducting, time of the meeting, when you are conducting. Okay. Then quorum for the meeting of the COC. So we are having provisions relating to quorum. Okay, so regarding the meetings of the COC under regulation 31 of the PP-IRP. Okay. Then participation through video conferencing. Is it possible? Yes, you can participate through video conferencing also, regulation 32. Then conduct of the meeting, we are having the provisions relating to how to conduct the meetings in regulation 33. Okay. Then committee with creditors in class. So there is a possibility you can have committee with creditors in class. In such cases, as already we have discussed, the committee, the creditors in class, they can be represented through authorized representative. Okay, creditors in class, generally they don't have any say. Directly, they cannot represent directly. So they are expected to be represented by authorized representative. Okay. Then voting by committee. So regulation 35 of the PP-IRP provides for the provisions relating to voting by committee. So more or less these provisions are similar to the regular CRP process only. Okay. Then once we are having a class of creditors, as already we have discussed, you are expected to appoint the authorized representative. So even authorized representative also can vote. So while he is voting for each and every creditor, he is expected to vote according to the instructions given by the creditor. Okay. Then voting by electronic means. Yes, there is a possibility you can conduct the voting through electronic means also. Okay. So let us recap what we have discussed till now. Till now we have discussed about what is PP-IRP, prepackaged insolvency resolution process. Okay. Then who is eligible under PP-IRP? All MSMEs, and where the default is less than 10 lakh rupees, then in such cases PP-IRP is applicable. Okay. Then who can be appointed as a resolution professional? Any person who is eligible to be appointed as an independent director, such person can be appointed as a resolution professional. Okay. Then we have discussed other eligibility conditions also. He should not be related, his partner should not be related, like that. Okay. Then how to initiate PP-IRP? Generally PP-IRP is initiated by corporator. Okay. Then they are going to make an application So once the application is admitted by the tribunal or adjudicating authority, then PP-IRP process will continue. Okay. Then we have discussed about the duties and powers of resolution professional. And please remember, when we are discussing the duties and powers, in this lesson we have not discussed in detail intentionally. Why? Because already while discussing the CRP regulations, regular CRP process, we have discussed in detail about the duties and powers of resolution professional. In one lesson, we have discussed about the duties and powers of the resolution professional in another lesson. Okay, so that's why in this lesson we have not discussed in detail. Okay, then we have discussed about the formation of the COC, how to form the COC, and while forming the COC, there is a possibility even operational creditors also can form a members in the COC. Okay, where if you don't have any financial creditor. Okay. Then subsequently we have discussed about the procedure governing the meetings of the COC. So how you are going to govern the meeting. So more or less even these provisions are also similar to the regular CRP process. Thank you.